Good afternoon and welcome to the Legal Connection with Toni and Cheryl. Toni and I are here today. You can listen to us on 104.5 or 106.1, or you can watch us live and listen to us on Facebook. And also tomorrow, Google Play and iTunes at ourlonestar.com. You can download that and listen. If you want, today we are continuing a conversation that we had last week about preservation of error is what we called it.
Yes.
But it's preparing what that essentially is preparing the record in trial. You know, those court reporters, they're taking the record, they're taking down everything that was said, so that if you get a ruling that you don't like at the trial level, then you can appeal it. And the appellate court can look at everything that happened, everything that was said.
If you know going in that you have got a slam dunk case, there's absolutely no way you're going to lose, then you're not going into it with the right attitude. You've got to go into it preparing to be able to bring up why you might get burnt, and then have that ready on appeal. And that's what we're talking about today. And I'm going to read just a little brief introductory statement because it's such a great statement. And we talked about this a little bit in the last show about preservation of error, and sort of we went over sort of an abstract of the topics that you need to go over. And today we're going to go over a little bit more detail of some pointers and tips that you may need to bear in mind, whether you're pro se, representing yourself, maybe in small claims court or whatever, even though they don't have as strong of a ability to preserve error on that level because you can appeal to the county court. But pro se, or whether you're a new attorney or an attorney that is practicing an area you're not comfortable with, or just for a refresher, these are amazing pointers. So, but appellate practice is every bit as strategic as trial practice. So don't be thinking, I'm not going to be thinking about that in my trial. Be always having your eye on, like a warranty, I might need to do this and to make sure that my case is warranted. Okay. On appeal, the appellate practitioner should look for the equities in addition to identifying the legal principles that control the case. Sometimes the equities that could sway the appellate court in your client's favor can be found in the underlying facts of the case.
Right.
Sometimes those equities can be found in a skewed nature of the way the case was tried. There was a mistake, or maybe something came up with the judge or your jurisdiction or your venue, or there was a bias, or there was bikers wearing vests that decided to come in and sit while the jury's there. I mean, there could be a litany of things that are going to affect your case while it's going on that you need to be aware of, that you need to make sure gets on the record if something goes wrong.
Well, Toni, like if you say a bunch of bikers showed up in your case, how would you get that on the record?
Well, funny you ask. That happened to me in a case that I had. It was a super aggravated sexual assault case, and my client was in every way innocent. There was no evidence. There was no DNA. He didn't do anything. It was just an angry...
He was the accused person, your client?
He was the person charged, the accused, but the mother-in-law, or the grandmother of this 5-year-old, wanted custody. Her son was being deported. The daughter, she had done all kind of things for the daughter-in-law to try to get her out of the picture by turning her in with trumped up, child abuse. You left your kid alone for 5 minutes in the car, whatever. And but she was very good about manipulating the system. And she called when they were going to get married, my client and the daughter-in-law. Not the daughter-in-law. They weren't married. That was why the mother-in-law now wanted the kid. She wanted to make sure that she still had access to her all the time and that she was raising her. And so she needed to, and she knew that now that this girl was getting ready to get married to my client,
her son,
she was going to lose the ability to see this child all the time and raise another child. Not that her son was all that great. Her son was in all kind of legal trouble. And so she waited until my client and the daughter-in-law, or I want to say daughter-in-law, the mother of the child, had custody, and they had to drop the little girl off. They were being nice. They were like, we'll just let you watch her for a while. And she took that advantage of that, and she went to the emergency room with the little girl and said, I think she's got, a venereal disease or whatever. And there was nothing wrong with her. I think she may have had like a urinary tract infection or something. But she said, oh, no, that she has been raped and all this other stuff. And the police came and arrested my guy where he worked. And they had nothing. That was all they had was that allegation, nothing more.
Wow.
And so it was a felony charge. We went to trial and during trial, all these bikers showed up in all their vests, and it was to protect the innocent, and I forgot what it was, but they all lined up in the hallway as the jury was filing in, and then they went to the courtroom all dressed like this. And so I brought it to the attention of the judge. I'm like, Your Honor, this is completely inappropriate. They're convicting my client before there's been any testimony, and it was really bad. And so I had to get that on the record. And that's the kind of thing you're looking for, things that are completely out there, and
that would never get on the record if you didn't make sure it was on the record, and you do that by objecting, and informing
and
the court.
motion in limine. We're going to talk about that, things that come up. I wouldn't even have known to move in limine for that. That was sort of out there. But in another case that I did, a murder trial, and that one we won. My client got exonerated, but not because they did everything they could to make sure, and I say the prosecutors as well as the ex-wife. And the prosecutors were kind of playing dirty. They had taken all the mail and all the correspondence that anytime somebody visited, they took it and they recorded it. And they can record that even if you're in the big, busy area where you think they can't hear, they can. They got all the mail, they subpoenaed it, and they brought it into trial.
That came to the jail?
Yeah, anybody that visited him, they took anything they said and anything he said that wasn't attorney-client privilege, and they brought it up in trial. They were ready and the stuff was completely innocuous because he didn't do anything. Well, it was a bad case, but he didn't do anything. And they found out that he was having an affair with his brother's wife. And they brought that up, and she was a witness. And I didn't know they were going to bring that up because I never knew he said it.
Sure.
Because they didn't disclose it to me like they were supposed to. But it was not harmful error because his character with regard to whether he was going to cheat on his ex, we weren't cheating. She was cheating. My client was already divorced, or estranged. And, but the estranged wife, and they had already separated, got on TV. And she started making all these allegations, and the media was eating it up, and his face was everywhere. And she was making false allegations, and it ends up that I was able to eliminate that out because it wasn't relevant. Yeah. And it was hearsay on top of that because she was saying, things. But it was a really difficult case. But we're going to talk about motions in limine and how you keep these things out. Now, sometimes though the equities may be policy rationales that would influence the appellate court to want the rule of law to allow your client to recover. So you're also looking at kind of the atmosphere of what's going on, like the Trump impeachment, that kind of thing. Keep in mind that judges are people too, and they're exposed to all the kind of things that are going on the outside, and most of them are elected officials, and so they're looking, particularly like an election year like this year, at what their electorate's looking at too. So they want to use that in their campaign if it's a hot, contested election. Yeah. Now, the equities are only gift wrapping. The presents inside of the wrapping are the legal principles on which the appeal is based. Equity should not be overlooked in handling appeals. Now, another key appellate strategy is to take on the long view to understand that a good appellate strategy really begins at the onset of the case, just like we were talking about. It is at that point where the record is developed that can support an appeal or make an appeal unwinnable if you're not careful. After all, the winning appellate arguments must stand on the three-legged stool of the error that is preserved and that is harmful. Has to be harmful error. And that we talked about that last week, where you could say, well, I wasn't read my Miranda rights. I have all my jailhouse lawyers that tell me, I know this has got to be thrown out. Well, if they were later able to get admissible testimony that supported whatever you may have said, then now it's not harmful anymore.
And it was voluntary.
Yeah, and so just because you have an error doesn't make it harmful. You have to have harmful error to be able to win on appeal. The legs of this stool must be put in place while the trial is in the trial court. The fertile areas of appellate success are covered below with rules and practice pointers, and I mean below in the trial court, for setting up a successful appeal. It's your warranty. Now, of course, in many instances, the appellate practitioner is confronted with the case for the first time after trial, because the appellate lawyer is, typically you don't have trial lawyers who also do appellate work.
Right.
It's really good if you have someone that does both because they already know the case, but they also have a lot more liability because they did the case and they can't answer anything. I do both because I find it a lot easier to win my appeals when I've done the trial work because I've been doing this exact thing. I'm preparing for the warranty of an appeal. Now, but even then, post-verdict and post-judgment motions may provide a vehicle to assist in setting up appellate arguments. even after the jury's come back with a verdict, or the judges come back on the bench trial at the bench with something that you
you've
weren't
gotten a summary
happy
judgment.
with, then you've still got your post-judgment motions: motion for a new trial, motion for judgment notwithstanding the verdict, motion to get evidence in an informal bill of review is going to be, an offer of proof is one that's before the jury goes in, and a formal offer of proof to get a bill of review way after the judgment's been entered is also an area where you can go, even after you believe your appeal, you can't even go back to it. You can still bring a bill of review in many cases if you had a constitutional error. So don't give up just because the judgment may have come out against you. And when the appellate practitioner is not involved until the case lands in the Court of Appeals, the savvy appellate lawyer, like us, can still scour the record already made to identify arguments that are sufficiently preserved to provide effective fodder for an appeal. And it starts all the way from the beginning when you're interviewing your client, starting from the beginning of pleadings and what have you. Now, we could go into a lot of detail, which we will go into enough detail to hit some finer points in our show, because this is not, a full-blown course in law school. But there are some areas that are not known to pro ses or maybe attorneys that don't do a lot of trial practice that you as a client should be aware of. And one of those is motions in limine. I think they're really important, and you're going to tell us a little bit about those.
I just want to add to what you said, because we talked to our people are listening, are pro se, and the problem, like you said, you just touched on it, is that a lot of attorneys don't know how to set up a case for appeal. But, it's a nightmare.
Because it's such a different area of law. When I've done, I really try to focus on appeals. What I discovered was that I would say 99% of the attorneys that I work with is my colleagues, and they're brilliant lawyers. They're not even admitted to the bar of the United States Supreme Court because they've never taken an appeal they've not persevered to that extent when they've got winnable cases, but they just haven't pursued that. Nor have they gone in the federal direction with the bill of review when they completely, when their clients have been their constitutional rights have been violated, when you should be able to preserve that jurisdictional argument with a bill of review, even after you believe you don't have any argument and your appeals have passed. So you need to go forward with that. But again, a lot of trial lawyers don't really focus on the appellate part of it because they have such slam dunk cases. They know the general areas of preserving error, and they're very, very good at it. But hopefully we'll touch on some areas here today that are some things that the client can also bring to their attention they don't know.
And that's kind of the point that I was trying to make. If you're representing yourself, I think it's important.
Or if you have an attorney and you might be just on the lookout to make sure, like, we're girls, and I would say that in general we don't do car mechanics. We usually leave that up to our guys, and that's the kind of thing they are more interested in.
Right.
So they have more expertise in that. But certainly with my experience now with my number of cars I've had broken down, I know what questions to ask. But even with the more finicky ones, the more things I know to ask, the better off I am with someone repairing my car, so that I know that I'm getting not getting ripped off when they're repairing it, or if it really is something that I should just give to cars for kids or something and not even bother with it.
Right. Okay, so we're talking about pretrial motions in limine. The purpose and effect of a motion in limine are frequently misunderstood. A motion in limine is a procedural device that permits a party, one party or the other, you usually have two parties in a lawsuit,
Two sides, right?
To identify before trial certain evidentiary rulings that the court may be asked to make in the trial.
Right.
So it's asking them to make them beforehand, right? The purpose of the motion is to prevent opposing counsel from asking prejudicial questions and introducing prejudicial evidence in front of the jury without first asking the court's permission.
And I'm just going to say that generally, I want to say generally, in Montgomery County, most of the courts have a standard motion in limine that you follow. But if you prepare your own, you can also attack some areas that you know will come up that are not in that general motion in limine. That the general motion in limines are just they're just addressing the standard Texas rules of civil procedure, things that you're not supposed to bring up. You shouldn't bring up hearsay.
Right.
You can't do this. You can't do. It's just a sort of
full
a list,
boilerplate,
just a bullet list of things that we're reminding you can't do this because it's against the rules.
And that's on the court websites,
Right,
the motions
right,
in
and you can
limine.
look at that. But what I like to do is I like to prepare my own that's going to address issues that may come up that are that I know that if it's brought up and I have to object, that the jury is going to see that it's something I'm concerned about, and I don't want that. I want a ruling in advance by the court as to whether or not they're going to let that in. And I'll still object, but I know to prepare my strategy better if up front I know how the judge is going to rule. She doesn't know the case, or he doesn't know the
So
case.
for example, what do you not want to come in that you would object to?
We had, and this wasn't in my favor, it was against me, but it was a good strategy on the opposing counsel's part. We recently did a jury trial where the opposing side is inspired with his nephew-in-law to defraud the mother's estate so that and they put all of the they fraudulently moved 3 days before the mom died, not knowing that she was going to die so soon. No one knew that. I think he might have had a hand in it, actually, to move all of the property into a trust, a phony trust, one that the mom did not set up, so that they could be able to defraud the estate and take all the other heirs that were entitled to something, and they'd have nothing under the pretense that the mom set up a trust, and it was all here under the trustful, watchful, trusted eye of the bad actor, right? Mm-hmm. Well, the bad actor had conspired with his bad nephew-in-law, who had also already been charged and I think at that point convicted of embezzlement with banks and what have you. Well, he ended up in a different case murdering his own stepfather under another estate a case. So it was the same kind of thing. Somebody was being murdered over property. Mm-hmm. And so the opposing side in this case did not want me to bring up that their client had conspired and made a trustee and put on all of these accounts that belonged to the deceased mother, the murderer, the embezzling murderer. Mm-hmm. And so they approached the judge with a motion limiting and said, we think that it's too prejudicial for her to be able to bring up, her meaning me, that it's too prejudicial that it be brought up that the trustee, the designated co-trustee and the partner and the person that set up all the accounts is a murderer now because at the time he wasn't. Well, that's just you. I think, what is the adage? You are who you hang around with. Mm-hmm. That is what was going on, and I needed to bring that in. But they were able to get a ruling from the judge that if you want to bring this up, you're going to have to approach first. Mm-hmm. And
which is exactly what we're talking about.
Right. And at that time, I had a felony admission of embezzlement with a bank, but they had not, the murder trial had not gone through yet, and now it has. So the judge would not let me bring up that this guy was a murderer, and it was a really good strategy. So that's the kind of thing you want to do, depending on which side you're on. Now, of course, when you see their motion limit, you're going to argue it's not that prejudicial. In fact, it's core to the case. They committed fraud. This is kind of people that would commit fraud and need to look at this. But the judge said, well, I'm not going to let that in. So I believe, because I did object on the record, that I believe that it wasn't prejudicial. It was relative to the very strong point in my case. I have a point of error, but they also, if they had not brought that up, that would have been error on their part. So that's the kind of thing we're bringing up was even if it's something that should come in, if your attorney argues that it's prejudicial, you can give it a shot, and it may not come up in front of the jury. Because had that come up in front of the jury, I would have been in a much better place than as far as
absolutely.
Argument.
And then the jury would have known what was actually going on too.
Right.
But it's important for our listeners to understand that these are tentative motions. You make them at the beginning, then you have to make them again in
Outside the
trial.
presence of the jury.
The motion in limine, and they do not preserve error on appeal. In order to preserve error on appeal, you have to do what you were just saying.
You bring it up, but even if the judge rules in your favor on a motion limiting and says you cannot bring it up, if you don't attempt to bring it up and then make your objections of record, and then you
during the trial
you ask to do You ask
Offer of
to
proof.
make an offer of proof outside the presence of the jury.
And that means
That means that you're going to present the evidence that would have been presented to the jury and why it's important.
you're going to read it to the court
You're going to
reporter,
read it to the
basically.
court reporter, make sure you
Just
do that.
put it in the record.
So a lot of many attorneys believe that the motion in limine, I got a ruling on it, you can't bring it up, and they
Right.
think they're covered. Oh, the judge ruled against me, I can't bring it up. Oh no, you've got to not only you've got to address it before the judge, find out how it's going to be ruled upon when it is brought up, and then bring it up again. And you're not in breach the motion in limine if you try to bring it up. The other side's going to object, and you just say, as the attorney that wants to bring it up after you've been ruled against on the motion, may we approach, and then that's when you make the offer. You're not doing it at the motion in limine at the
Pre-trial
hearing at the motion in limine. You're doing it during trial, and you never have to worry about the jury. All the jurors have to get up and leave. Don't worry about offending the jurors. They're doing their public service as jurors. They showed up. If they had the different things that allowed you not to come to be a part of the jury panel, kids in school, illness or whatever it is, then they wouldn't have come. But they were there. They understand that they get to go back in the back, and we always hear them laughing most of the time.
Yes.
So it's you want to make sure that you preserve that error in that way. Okay. So that's the motion in limine is not preservation of error.
Right.
It's really a tool to see how the judge is going to rule on something that needs to come in one way or the other. And you still need to bring it up, and you still need to make a legal objection. You still have to preserve that error of record. And if it does come out because the other side has breached the motion in limine, then you have to make additional errors. You have to move to strike, ask for sanctions. You do the things that you have to do to show that, Judge, we've already talked about this, and they brought it up, and they weren't supposed to. And so, and if for an example, an unspoken motion in limine, but it's one that is actually not even unspoken. It's just part of the standard motion in limine for DWI trials. Is you can't bring up the breath test that was done at the car because the portable breath tests are not admissible because they're not reliable enough, and so it's hearsay. And so I don't know if you want to consider it hearsay, but it's something that doesn't come in because it's not admissible. And so if your police officer who's on the stand happens to bring up, oh well, I did a breath test on the side of the car, that is. Now the jury's heard something, and if it's detrimental, and they've alluded to or outright said that they didn't pass it, and let's say that there was no evidence in that breath thing, he just lied. Let's say that they didn't even say that. Let's just say he lied. You can't object to perjury. You have to be able to walk through the person on the stand to prove they're lying. But if they bring up something like the breath test, it's hearsay, and you've already gotten a ruling on the motion in limine, then that's when you object. You move for a mistrial because it's already been discussed.
Right.
So you still have to do everything that or your attorney has to do within your power to make sure it's on the record and that it was a legal objection, that you have the proof in the record, even outside the jury, absolutely outside the jury, depending on which side is arguing it, to show the appellate court what's going on. And if it's the other side that sent it to you, then you need to preserve error by objecting, approaching, and moving for a mistrial and asking for sanctions.
Yeah, so you've just been talking about if it's granted, denied.
And let's go over, if it's granted again, what are the prongs to it.
If the trial court grants the opposing party's motion in limine to preserve error in the exclusion of the evidence, you must approach the bench during
So
trial.
that's the first thing.
Formally
Object and approach the bench. You jump up like a bunny. Objection, may we approach. Okay.
And then you formally offer the evidence,
Right.
obtain a ruling on its admissibility,
Yes.
and make an offer of proof. So walk us through what that looks like. You approach, objection, Your Honor, may we approach.
So we'll go a step further. We've already had our motion in limine hearing, which not all trials have that, but you want to make sure this one it happens for you. That's the proper thing to do. It doesn't matter how low the court is, even if it's JP court. A motion in limine is simply the Latin words for motion to limit what comes in. Okay, and I may be wrong on that exact Latin interpretation, but close enough. So you've got a ruling. Can't bring up breathalyzers. Okay, just that example. And the other side brings it up. You hear it coming out. You think it's getting ready to come out. Objection, Your Honor. And then you say, may we approach? Whether it came out or if it, depending on whether it came out or not, depends on just how your
Far
objection is
they
going to
got,
go,
yeah.
right? And you approach the bench, you formally offer what just transpired, the evidence, depending on which side it is. You object now if it's granted because you wanted evidence in. So I'm looking at it both sides. If they brought something up they weren't supposed to, you're objecting and you're going crazy, you're making sure it's on the record. If it's something that you wanted to come in and they're objecting, then you approach, and we'll approach that one because that's the one that I think is probably one that gets overlooked a lot.
Yeah.
You think you've got an error, a preservation of error because the motion in limine, ruled one way or the other, and you don't. So because you can't go to the appellate court and say, well, the judge wouldn't let me bring it in. That's not true because the judge doesn't. The judge may. This is like your reconsideration moment. So you approach the bench. You say, this is what you wouldn't let in before, Your Honor, but this is why it needs to come in. They've already discussed it. It's now relevant. It's already come in through other witnesses, whatever the argument may be. And then you formally offer the evidence outside the jury. You mark it. They're going to admit it for the limited purpose of it getting into the appellate level, so it's an offer of proof. They're going to obtain a ruling on its admissibility. The judge may reconsider and say, go ahead and bring it in. And it never hurts to keep trying. If you got something that's that important, the other side obviously really doesn't want something in. If it's a letter that's the smoking gun, or if it's the smoking gun itself, they don't want it to come in. They're going to keep arguing, and you just keep trying to get it in because it's that important. Obtain a ruling on the admissibility. If the judge still doesn't let it in, we don't know if they're biased toward it. They may not understand. It's that important that this evidence get in because that's what's going to win your case. Then you get a ruling on it. Now that you've got a ruling on it, you're still not done if it has not been admitted to the court reporter with the offer of proof prior to the jury going into deliberations. So if those four things are done, then you've preserved error on something very critical, and you're burning mad. You're wanting to bring this up because it's so critical to your case and the judge has ruled against you. But if you get it in there, now the appellate court can see why you were so burning mad.
Yeah.
Maybe the judge isn't up for re-election again. Maybe the judge is really good friends with the other side. Maybe the judge just doesn't understand because she just had a case that had something similar, but your facts are different, and that hasn't come out yet. And don't rely just on that one ruling. Try it again. Object may we approach, because throughout the life of the trial, it may come up that now it is admissible. Now it's completely relevant. Something's come up that's made this through a testimony, which is not hearsay. Now you can bring it in. And I did that in a trial recently where I couldn't get it in, and finally I got something that I literally had my piece of paper sitting right there. I had my evidence. Of course, the other side couldn't see that. I was looking at it, waiting for that opportunity, waiting for that question to come through where I could get that in. And then we got it in.
And then it happened.
Yeah. So that's what happens when the judge grants your motion in limine. Now, what happens when the judge denies your motion in limine? They're letting something in, and you're like, I can't believe the judge is letting this in. So what do you do?
Well, you make a timely objection at trial, and you obtain a ruling on its admissibility. So you just want to have that in the record for appeal that you objected, and you asked, and the judge said no.
You're still going to try again. So the motion in limine is just that. It's a pre-trial. How's the judge going to rule on this? You still got to get it in the record at trial. You still got to get all that in there. You're not making. I guess you could have a stipulation with the opposing counsel that. I'm not going to try to offer this, which would really be dumb, but I'd like to stipulate to get it in as an offer of proof pre-trial. I mean, I guess you could sort of line it up like that if you wanted to, but I never do that. I know that it seems inefficient, and the other attorneys, the opposing counsel will always argue, judges are not being cooperative, she's not working with me. If we have similar exhibits, well, mine's already in, why can't we just stipulate to that? Because you don't know unless you've had a lot of time to look at the exact exhibits that they're getting ready to enter, and you've had, like in federal court, you have to exchange them 3 days in advance, and you may be able to identify that they're exact same exhibits. But a lot of times they aren't exactly the same. It may be missing a signature. It may have one extra line item in it. It may be missing a page. It may have pages added. There's so many things that you really, in the throes of trial, don't have time to look at. And so I'm just like, I'm not trying to be ornery, but let's just work this through. I see your exhibits are similar to mine. If they're exactly the same, or maybe you even like theirs better, then yeah, I'm going to stipulate to those coming in. But rarely do I stipulate to all the exhibits that match, because you really don't know if they're playing fair. And I would say probably about 90% of the time, and it's really sad to say, attorneys don't play fair.
Yeah.
They're trying to slip something by on you. So.
Yeah. That's true. So that's what you do. You get it if it's denied. You make a timely objection at trial, and then you obtain a ruling. It's got to be in the record, and then, like you said, you try again.
Okay.
Look for that opportunity.
Now, let's recap what happens if that motion to eliminate is violated. What happens?
If opposing counsel violates an order granting a motion in limine, like you just said, a lot of times they don't play fair. They know that the judge has said this can't be
Or
discussed.
that maybe you're not paying attention when it comes up. It comes up and it's in. You had a motion in limine. You've missed the boat because they've already said it because your client's talking to you or something, or they're trying to tell you something, which they always do and they mean well. But you're running a trial here. You're having to watch everything that's going on. You have no idea if a juror is winking at the other opposing counsel or sleeping, or you're watching all this stuff, and the witness or the opposing counsel is now getting something out that should be objected to. And so what happens next?
Okay, in most cases, an instruction to the
Well,
extent
for the violation, you're going to make the timely objection.
yes.
If possible, request a curative instruction. That's when you miss the boat. Your Honor, may we approach? Could you ask the jury to disregard, because that should never come in. And the juries really will disregard it, because I've heard them when we've gone after the trial. They'll say, "Well, we were told not to think about or listen to that," even though they've been tainted. A lot of times they really will
try.
listen to it.
They do.
And if necessary, move for mistrial. That's really important. You do the last step, because it could have been so tainted. The judge may also agree that hearing about, it's an ironclad rule, hearing about a breath test by the car coming in and DW. I keep bringing that one up because it happened to me.
Well, and it's easy for the audience to identify with that. They know so many people that have had DWIs.
Right. But I made a mistake in that case, and I learned from it. You always learn from your mistakes. That the only thing I didn't do, because I was so stunned by this coming out, that and I wasn't even sitting by my desk. I was watching the cross from a different angle, so I wasn't there with my papers and everything. So I was a little bit disoriented the way they had the screen done. It was kind of weird. I was in a smaller court. I didn't ask for a mistrial, and I learned we did actually get. The charge was dismissed.
Yeah,
the jury came back
later.
against us because of that very same thing.
I know.
And we did get the case dismissed. But if I had asked for mistrial at that moment, I probably should have gotten it. I probably would have gotten it, because I got it at post-trial after the fact. But I could just kick myself, because we went on, we had the heartache of having to go back to trial, and, he had to get a new bond, a post-trial bond, and all that stuff. And so it was strenuous, because I made that one little mistake. So.
So you say objection, request a curative instruction, and ask for a
Well,
mistrial.
you're mad. You should be mad, but also have the foresight from what we're telling you here today on the show to say, objection, Your Honor, you ruled against this. They brought it up. I want sanctions. And then you approach, because the other side doesn't want to hear you saying that kind of thing. The thing is, you're making a big deal out of it, though, and now the jury hears, and if she doesn't rule in your favor, that's why you want to say objection from your approach, even though you're mad. And they all see that, too. And then you make the timely objection. You ask for the judge to make a curative instruction, and then you ask at the bench for a mistrial. Now, if it's bad enough, you can do it right in front of the jury, because the jury, if it's that bad, if they have said something completely that, and I can't think of one, but I'm sure a lot of other attorneys or people listening can think of something where they've said something that is so bad that you have to get a mistrial at that point. I don't know what it would be, but it would be, I'm thinking of the OJ case. I can't think of what it would be. But anyway, so you were telling us about...
The only thing I remember from the OJ case was that the prosecution was relying on law that had been overruled, And I always think about that. Okay, so we're talking about... to the extent which you must pursue an adverse ruling after the trial court sustains your objections varies by circumstance. You were just talking about that. Motion to exclude, unlike a motion in limine, which preserves nothing for review, a pretrial motion to exclude testimony can preserve a complaint about the admission of evidence. So that's for the appellate record, the motion to exclude.
Right.
And
So you
it's
can do
just
both
like
of
a
them.
motion in limine, but it's just a different motion.
Well, yeah, and I don't try to. I think it's Texas Rule of Civil Procedure 45. I could be wrong on what actually the number is, but if you call something, you title a document something, but it really serves a different purpose, it's kind of both, and there's a real gray area there. If you're asking for a judgment notwithstanding the verdict, or if you're asking for the judge to disregard certain jury findings or all of the jury findings, it's kind of the same thing, but it's got a few different standards. And so I usually, if there's something I really want to keep out, I'm not conservative about it. I will file a motion to exclude as well as the motion limine. The motion to exclude is something you usually will file maybe a week or two even in advance. You're filing that for the record, so it gets in on the appellate record. Motion limine is usually a pretrial motion that's done sometimes at the pretrial conference a few days before trial, 2 weeks before trial, depending on which court you're in. But a lot of times it's done just right before trial. It's usually not. They usually wait because they don't know if your trial is going to go that day because they've got a pretty large docket. So now.
Just the motion to exclude for our listeners, it's the same thing as...
Well, let me add one more thing about motions in limine before we go to motions to exclude.
Okay.
Violations of an order on a motion in limine are considered, and this is the law. This is not Supreme Court law, but it's been basically ratified by the Supreme Court by virtue of them denying a writ on the same subject. It's incurable if the instructions to the jury could not eliminate the danger of prejudice. Counsel need not request a curative instruction, but should instead just go directly for the mistrial. I ask for both. I want a curative instruction, and I'm asking for a mistrial. Why limit yourself to what you're asking for? If you get the curative instruction and they grant the mistrial, then you've got it. But why would you limit yourself by saying you want a mistrial when you don't get it when you should have asked for the curative instruction? So but all three things are the best thing to do. But truly, if it's something where the prejudice, and I can just use my probate example. If I brought up that this guy, the opposing party is best friends with a murderer, and it was an estate case, and he was going to kill my client, and the judge ruled against it. Now, he should have let that in, but that would be, if the judge told me no, and I said, I wouldn't say it because I'm not a witness, but if my client was mad and said it, which they always want to get their story out, then first the judge will try to sanction me for not telling my client about it. And when he takes a witness on voir dire and my client says, she told me absolutely not to say this, it just slipped out, Your Honor, I couldn't help it, I had an anxiety moment, they'll still try to sanction me for not having under control of my client because they're an arm of me. Those don't usually stick. The sanction is usually don't bring it again. If it does come up again, and they're not really that harsh. But I got sanctioned in a murder trial once because what did I bring up? I brought up something that the judge was really mad about. I can't even think of what it was right now, but it was Judge Carter up in the 228th, and he said, I told you not to bring that up. That the victim was a gang member. For some reason, the judge didn't want me to bring up that he was in a gang, and the reason that there was a gun battle was because it was over drugs and a gang issue, and my guy was protecting himself. And I thought it was a huge defense issue and I needed to bring up. This has to do with gangs. He's got gang marks all over him. Why can't I bring up that my guy had feared that there was gang activity? The judge just said it wasn't relevant. And when I had a witness get on the stand who was, it was the sister of the guy that was charged. She said it, and the judge shut everything down. He took the jury to the thing. He sanctioned me. I think it was not very much, but it was $100, and told me he was going to report me to the bar if it came up again. And I didn't even say anything. I was being sanctioned. But ultimately, we won that case. My client was exonerated for other reasons, and he withdrew the sanction. So the judges can also withdraw it. After they hear the rest of the story, they may also feel like the sanction was inappropriate.
I
so
see.
they're just people too. So you kind of walk a fine line of what you say and what you don't say. And sometimes, I would say sometimes you just got to get it out. Maybe the judge ruled wrong. But it's a fine tightrope walk. So it's better to get a witness to or the other side even, to get to where you need to go and take that road and do a strategic planning to get your evidence in. And if you can't, no matter what, then still preserve that error. And that's kind of the same thing. You're going to, it's incurable if it comes out and the judge said no. In that case, he believed it was incurable, but there was other stuff that wasn't harmful. We had other stuff that came out in that particular trial that showed that my guy should have been exonerated, and he was perfectly within his rights to protect his family. So
okay.
That's how we ended up winning that case.
That's good. So it was self-defense?
It was a stand your ground more than anything else. But sad case. Yeah. All right, so tell us about you were telling us about motion to exclude.
Well, it's not nearly as interesting as motions in limine, but it is an aspect of a motion that you and I think it's interesting that when you make those, they're kind of looked at as a running objection. Why don't you talk about?
Well, not even kind of. They are.
Yeah.
Which I don't like running objections because there's so much case law that says that if you get an objection, if you object and the judge rules in your favor, let's say for hearsay, you object because they're saying something somebody else said. Well, they'll say they try to do it again and you don't object. Well, that's not a running objection. And let's say I want a running objection, Your Honor, because they're going to keep trying to talk about what somebody else said and they're not here. And they're lying about what that person said. They're just trying to, they're lying about what the person that died said. They can't say that. Well, that you can't rely on a running objection for that. You're going to have to, every single time they start to open their mouth, you're listening for them. Well, they said, the minute the word said comes out, you're jumping up out of your seat objecting. And there's some, there's 23 or 24, and I can't remember the exact number of hearsay exceptions, excited utterance, maybe an ancient document, what have you, but
dying declaration.
Yeah, what all those are, but you're still going to object because you've got to get the objection in because it may not be within the purview of those exceptions. Now, a motion to exclude, according to another Supreme Court sanctioned case, Texas Supreme Court, a motion to exclude, in effect, accomplishes the same thing as a running objection. It eliminates the need to repeat the objection each time the evidence is admitted on a topic. You're not going to be able to get a motion to exclude hearsay. I mean, that's a given.
Right.
But a motion to exclude is something like you can't bring up gang activity. That's going to be, you already have it in there. You shouldn't have to jump up and say it each time. But don't take your chances. If you think, depending on which side you're on, if it's something that hurts you, you still want to do that. So, but you also want to take care in drafting the scope of the motion to exclude, which should identify both the subject matter of the objectable evidence and the source of the evidence. Because if it's too broad, you're not going to get it. So you've lost the purpose of your motion. Okay. So what can you tell us about preservation of error and voir dire?
Voir dire, it's one of the trickier areas for error preservation. There's an improper restriction in voir dire, and there are challenges for cause.
And the reason it's such a difficult one to get error on is because your jury panel doesn't have facts. They're just public,
listening.
They're just citizens trying to do their public service. And they're just listening to the questions. But the big preservation of error, I think, is when that somebody gets on that jury and they've not told the complete truth on their form.
Right. They know the defendant,
and it doesn't work in small towns because everybody knows everybody. But they may have had a situation where they lost in a case and it was favorable to you or the other side. It was such a strong part of the case that there would have been a prejudice that they couldn't have overcome. Or let's say that they flat out lied. I had a guy, I can't believe we did this, but we did a jury trial for a traffic ticket, my daughter and I, a long time ago. I was like, let's just try it. And we did it right before we had I was going to do a murder jury trial.
Oh, my goodness.
And we ended up losing the traffic ticket. And so you can imagine my anxiety when I was going forward. But we had a bad juror. He was a felon, and he ended up on a jury. But I wasn't going to go try to get it reversed because it was just a traffic ticket.
Okay, well, listen, Toni and I have been here today talking about preservation of error. We've been talking about motions in limine, motions to exclude, basically setting up the appellate record.
Right.
So I guess we'll finish this conversation next week.
We're going to do preservation of error, and we're going to have more details on more specifics on things that are critical and special pointers that you must listen to, that you must have, that are critical for you to be in control of your next trial.
And we want to remind you to
serve God by serving others.
All right. Have a great week.